Welcome back. In this session on the crash talk on guide to documentary credits refresher for CDCS preparation, we shall talk about examination of documents. We have seen how the contracts are drawn up, how the LC is being issued, LC application is written up, and then what documents will be called for, how the documents are presented. We shall now look at the examination of documents. Handling of the examination of the presentation under the documentary credit is very critical. Why? What we do to the documents is very important because our actions will decide in whatever capacity we are acting as a nominated bank, as an issuing bank, as a beneficiary, as to whether payment will have to be made on the right time or not. As a bank, first of all, the document examiner will record the receipt of the presentation because there is a significance of the date and time. What is it? To ensure whether document has been presented within the banking hours, on or before the expiry of the validity of the credit, and during the banking day. If else, it will be considered as a presented to be the next banking day, and then it may lead into a late presentation or a credit expiry situation. To avoid that, we have to consider whether the bank was closed on the day of presentation for reasons other than force majeure and things like that. So because of that, we have to record the date and time of receipt. We also have to see this because there are two concepts. So one is the expiry date of the credit, and another is the expiry date for presentation of the documents as called for by the credit. Because of this, second, we have to see whether the documentation presentation schedule is addressed to us. Maybe we may be acting in our capacity as issuing bank, we may be acting in our capacity as a nominated bank, we may be acting in our capacity as a confirming bank. We may have to play different roles under different LCs at different points in time. So when a presentation is received, we have to see whether this is a presentation addressed to us and in what capacity. What role are we supposed to play for this presentation? Are we the issuing bank for this presentation? Are we the nominated bank for this presentation? Are we the confirming bank for this presentation? Or are we just an advising bank and we are requested to receive and just forward the documents? We have to see what role we are supposed to play. So we have to look at the details of the instruction given in such a presentation schedule, and we have to see what service is demanded from us and how the credit is available. We may not be any of these banks. We may not be advising bank. We may not be nominated bank. We may not be confirming bank. We may not be issuing bank, and the documents might get presented to us. Then what will we do? We will act as the presenter on behalf of the beneficiary and present it to the bank with whom it is available. So we have to check whether it is available with us and what we can do. Will depend upon the relationship. Sometimes we may not have an account relationship with the beneficiary who is presenting the documents, beneficiary of a credit. So we have to consider how this party or client, being a non-customer of us or having no relationship, how do we handle? Do we try to do a KYC first and then look at the document, or what do we do under the presentation presented under somebody's LC by a party who is not related to us? We also have to look at whether proper disposal instructions have been given and whether communication channels have been established. They should say, in case of any event, who should be contacted, how they should be contacted. So the phone number, fax number, email address, postal address, name, resignation, all those information should be available in the presentation schedule so that the bank can decide upon how they decide to act upon the availability, nomination or relationship and what they have to do. Disposal instruction also has to be given so that whether document should be promptly returned or promptly somebody else has to be communicated and things like that. So these are part and parcel of the presentation schedule. Now, if a bank is presenting to another bank, the presentation schedule will be structured and professional. But if a beneficiary is presenting to a bank, it may not be in such a structure, but most of this information should be there or will be available. If not, at the point of presentation itself, it has to be returned asking for more information. It has to make references to LC number or other communications. It can say as previously discussed and agreed. It can say as per this LC number. So we will be able to pull out the LC and know what are the history related to this particular letter of credit or a documentary credit. The form of the credit, is it irrevocable? Is it transferable? Has it been a red clause LC and advance been paid? All those information we have to see. If it is back to back credit or not, we have to check from other references in the credit. Is the credit operative? Does it have any clauses saying document the LC will become operative only upon presentation of a performance bond or something like that, advance payment bond? If that be the case, if that bond is not on hand, then presentation of documents cannot be honored because LC is not workable at that point in time. So if it is inoperative, whether the related amendments or related performances by any of the party has been done to make it operative at this present point in time. Is the credit still valid? Is it expired? Has it been amendment received for extension or what it is? And if it is available with the presentee, when the document is given to a particular bank, is that bank capable of handling the document as per the nomination available to them? Is the amount available adequate under the credit to honor this presentation? Is the goods shipped as per the permitted? If cars are called and if vans are shipped, or if cars are called and then if instead of 5 cars you have shipped for 6 cars and 7 vans, so those things will have to be looked at. And then is the amendment on file versus the amendment accepted matching? Suppose you have received 5 amendments as an advising bank or a nominated bank, and the beneficiary is presenting 4 amendments. Then what is it? Are they accepting the next fifth amendment explicitly, implicitly? What is it? Because we have seen, in case an amendment is received, it is a duty of the beneficiary to express their acceptance or rejection of an amendment. If they don't do it, they have to present documents which are complying with the amendment to convey their acceptance. But if it is refusal, they cannot do it that way. They have to explicitly say they are not willing to accept the amendments. Why? LCs are irrevocable instructions, and unless a beneficiary agrees, LC cannot be amended or cancelled. How the presentation has to be settled? This is instruction that will be received by the party to whom the documents have been presented by the party who is presenting the documents. When it has to be settled and by whom it has to be settled. In spite of these instructions, the bank will have to decide how they will do it. If it is 30 days from site and if it is non-complying, then the bank will have to give a notice of refusal, and if they give a notice of refusal, 30 days from the date of further acceptance will be the due date. If the bank chooses not to give refusal, or if the bank fails to give a refusal, then the due date will be 30 days from the site of those documents. So who will have to settle? Is the bank willing to act per nomination, or will they receive the funds from the issuing bank and then pay? Is there a reimbursing bank from whom claim has to be made? All this information will have to be decided by the bank to whom the documents have been presented on or as a part of examination of documents. These are all forming part of examination of the covering schedule itself and the LC. Now, is TT reimbursement claims applicable? Is says can be claimed. Can we have a swift relationship with them? As a nominated bank or as a confirming bank can be claimed. As an issuing bank, have somebody else claimed and have we reimbursed the reimbursing bank? As an issuing bank, is it that the documents are discrepant and we have to ask for refund from the nominated bank or the confirming bank? So those has to be done. How to be paid, how to be reimbursed, and if it is dishonored, has the funds to be recalled or what? And who is to bear the charges? As per the credit, who will bear the charges for the actions that various banks are going to take? The nominated bank charges, the confirming bank charges. Is the issuing bank charges payable by the beneficiary, and so has it to be deducted from the proceeds, or is it the any other bank charges are payable by the beneficiary and the beneficiary directly presented the documents to the issuing bank, and so the confirming bank charges, nominated bank charges, advising bank charges, these are pending and there is a claim against this lying with the issuing bank. All those information will have to be checked, and then if proceeds, if any, payable, has to be paid only after deducting such charges if they are payable by the beneficiary. Had there been a transfer or assignment, if yes, such conditions have been met or not? Is it a back-to-back structure? If yes, then are we able to transpose these documents? That we will see after we find these documents are complying. If we find these documents are discrepant, then transposing these documents into the back-to-back structure will again might make those presentation also discrepant. Now, the availability of installment and revolving credit matters. What is it? If it is a revolving credit, once a presentation is made, we will have to reinstate the amount of the credit. Or if it is revolving with respect to time, any number of times he may make presentation under the revolving credit, and we have to ensure that the presentation is within the overall liability as an issuing bank we have undertaken. If it is installment shipment, we have to ensure if a particular installment is not shipped, further shipments the LC is not available, and the beneficiary's presentation will have to be refused, saying previous shipments has not been shipped, and accordingly LC has become null and void. Please go and get an amendment for the LC, letter of credit. If the presentation is post acceptance of certain discrepancies, now issuing bank will check whether they have given any. You may negotiate subject to if other things are okay, or the nominated bank might have received a message from the issuing bank saying you may negotiate these messages subject to the discrepancies noted in your message, and then the nominated bank will have to write in their covering schedule that this negotiation is subject to or in compliance with their confirmation that documents may be taken up subject to certain discrepancies. The documents will have to be examined as per Article 14. The documents examination and the response will have to be within 5 days after the receipt of the documents, after the presentation, 5 days after the presentation. If the documents are complying, they have to be honored as per Article 15, and if the documents are not complying, they have to be handled as per Article 16. Article 16 tells about how it has to be refused and what should be the disposal instructions. Sorry. The document examiner has to read the letter of credit in full. The UCP and the SPP had to be read together and in completeness. The the letter of credit received may not be following the SWIFT standard strictly, and so it has to be read in full, so that certain conditions will be mentioned in document record field, certain documents will be recorded in additional condition field. Ensure there is no other empty 701, the continuation of the message, so that all the information is available at the time of checking. Ensure how many amendments are, how many is available. Sometimes if the value is booked and if it is considered as a risky transaction, the nominated bank may go back to the issuing bank and also ask, is there any other amendment other than what has been received? The document examiner has to list out the discrepancies in detail, identify the item, the document, and the operation. So they have to say in which document, which item they are considering as a discrepancy and why. They will say this particular information not as per LC, this particular information not as per UCP. So, are the documents dated prior to the credit issuance date? And if it is acceptable, normally it is acceptable. But if the LC has any other clause that it's not acceptable, then it will be a problem. Is an expiry of extension date extension applicable for expiry date, extension applicable for last date for presentation? Is it a post merger situation? What is a place and date where it is to be presented and where it has been presented? Actually, sometimes the LC may say the LC is expiring the counters of the issuing bank, and so the beneficiary will have to ensure the documents by courier reach the issuing bank on or before that date. That is why most of the beneficiary will insist the LC has to expire in their own bank in their own country, so that it will be easier for them to make the presentation till the last minute. Applicability of partial shipment, whether multiple documents have been presented. Credit by itself, because UCP says partial shipments are allowed. If the credit prohibits, then what will happen? If multiple transport documents are given, is there multiple means of conveyance used? Are the shipment by multiple vessel? Are there multiple onboard notation? How it will impact the partial shipment concept, whether it is acceptable? Whether a transshipment has happened, whether credit is allowing transshipment or credit is not allowing transshipment. Is there a tolerance? If tolerance is there, is it with respect to quantity or with respect to amount? Is it proportional? And installment shipment, whether it has been not made and so the LC is null and void at this point in time. All this information will have to be noted by the document checker. The document checker will also have to see whether is there a draft, and if there is a draft, is it drawn on the right drawee, and if it is drawn on the right drawee, are we in our capacity as a nominated bank or confirming bank willing to accept such a draft, or is it drawn on the issuing bank and so we have to negotiate? How is it? Is transshipment, what is the credit saying about transshipment and what is the document indicating with regards to transshipment? Will there be a discrepancy? The places and ports, as mentioned in the credit, is it transposed in the transport document properly? Is it used as a permissible way? If a range is given, a specific port or the actual port will have to be mentioned. If an intended vessel or intended port is there, is the onboard talking about only the date, or is the onboard also talking about the actual vessel and the actual port? That will have to be examined. Then the examiner will have to examine about the impact of the last date for shipment given in the credit vis-a-vis the dates mentioned in the transport document. And we have to check whether in case there is an onboard notation or any other indication in the transport document, that date will be considered as a date of issuance of the transport document or a date of shipment. Goods description. Is the goods called for in the credit mirroring or corresponding what is given in the credit in the invoice? Is any other additional goods given? Is the goods not called for given? Is a free of shipment mentioned there? Is it acceptable? How we will refuse that? In other documents, it need not correspond, but it can mirror, or it can, all the information given there may put together give the same meaning or the impact. With regards to goods description, even spelling mistakes could be allowed in certain circumstances, except for the fact that model 123 should not be written as model 321. This is example given in the ISBP. So MODEL written as MODLE will not by itself become a discrepancy. What are the documents required by the credit? What are the documents submitted? Is the stipulated document submitted? Is anything extra submitted? If some additional documents are submitted, will it be disregarded or will it be used to ensure whether they are to meet the non-documentary conditions of the credit? This will be checked. Now, documents required might be written in the documents required field. It might be written in the additional conditions field. It might be written in so many other places. In the goods description field also, sometimes you will write documents. What it will say, goods description is ABC, and then it will say this particular document will have to evidence this particular thing. Certificate of quality has to be submitted to evidence the goods as per above description has been supplied. So it is possible. Sometimes some banks do write in such a way because of the way the overall LC is structured, and so the document examiner will have to check what is written where and ensure it is compliant. What documents are issued by whom? If the LC is making a clear specification about transport document has to be issued by not by multimodal transport operator, not by freight forwarder, but by the carrier and things like that, then sometimes we can find LC saying the name of the carrier they will give, and it will be issued by one of these three, one of these four, and not by this ABC like that. So who has to issue the document, and what document has to be issued by him, what function it has to fulfill? So if a certificate of quality is called for, we will not be able to ensure. If it is suppose a shipment of coal and say certificate of quality, the bank will not know what quality has to be there. Bank will not be able to ensure any specific caloric value of the coal. Bank will not be able to ensure the size of the coal particles. So the letter of credit will have to say what is to be ensured and in which document it has to be evidence, and then the nominated bank may be able to examine the documents for compliance with such a requirement. The examiner also have to see how the consignment is required, to whom it has to be consigned and how it has been there. If it is a non-transferable document, if the letter of credit calls for consent to the order of issuing bank and the document says consent to the issuing bank, it won't become a discrepancy. But ultimately, if it is consent to the order of the beneficiary of the shipper, then we have to ensure it has been properly endorsed to ensure the title under the transport document, title under the insurance document, everything gets passed on to the issuing bank and the applicant ultimately. We have to look for onboard notation, ports, and shipping marks. Having extra information in shipping mark is not a discrepancy. Sometimes only container number will be mentioned. It should not have any defective condition of the goods or packing. Or if there is an on-deck shipment, then the insurance should have evidence of additional cover called a JWOB. The transport document should not be closed, but need not have the word clean, or the deletion of the word clean is not an error. All those things will be checked. Whether it is a charter party. If it is a charter party, then we will not check the charter party agreement, but we will check as per the respective article of the UCP. Insurance. Is a cover note acceptable? What has presented is it a certificate? Is it a policy? What is called for in LLC and what is submitted? Is it acceptable? Because if a policy is called for, then submission of if a policy is called for, submission of a certificate is not allowed. If a certificate is called for, submission of a policy is allowed. What is the effective date of the insurance policy? If a warehouse clause is given, that does not mean cover is effective prior to the date of issuance of the insurance policy. Is the insurance policy date and the transport date satisfactory? That is, does it say that cover is effective from the date of shipment? What are the other additional conditions given in the letter of credit? Are there non-documentary conditions? Is these conditions discardable, or is it to be related to some other document? What is the presentation period? Does the LC state 7 days or 14 days, or we should go by the 28 days allowed by the credit? How to treat a stale document? Regarding confirmation, what does the credit say? Does the credit say confirmation is available, or is that to be added by a specific bank? If yes, whether confirmation has been added. If confirmation has added, are there in terms and conditions of confirmation which the nominated bank will have to meet? All those things the document examiner will have to check. Then with regards to reimbursement, article article uh, reimbursement. If the credit says the reimbursement is subject to URR in the field 40 of the MT700, then we will have to check, or we will have to abide by the uniform rules for bank-to-bank reimbursements, which has been dealt in detail in another series of the videos. If it is not there, then the LC has to say that reimbursement authorization has been given to some bank, and the nominated bank may claim from that bank in case the documents are complying. Banks are not supposed to claim from the reimbursing bank if the documents are not complying unless and until the issuing bank authorizes them to do so. The examiner will also have to check the charges are payable by whom and how it has to be recovered. The document examiner has to check, are there any amendments? The amendments have been accepted or refused, and when the amendments become effective. Suppose the amendment says this will be effective within 7 days of receipt by the advising bank, in respect of the fact that a beneficiary agrees or not. Such clauses will have to be discarded. Amendments have to be accepted in entirety. If there are three different things, the amount, the date, and the document record changed in an amendment, and the beneficiary says, I will accept the enhancement and amount but not the changes in the document, that cannot be accepted because it has to be refused or accepted in entirety. Implicit acceptance of the amendment is possible by presenting documents which are conforming to the not yet accepted amendments. And sometimes a confirmation might not get extended to the amendments, and that has to be kept in mind by the nominated bank and the beneficiary. If the amendment is detrimental, then the beneficiary consent will be called for by the credit, and the beneficiary has to compulsorily respond to such a request.